weapon at the door. If, however, we're not at that level, and there is a high probability that someone in this room has a concealed weapon, then it's your right to keep and bear arms in protection of yourself. And that was the intent of the law. And there's a lot of flipping around, and everybody's kind of, I know there's a couple of businesses and even the state, a couple of state departments are starting to turn one section against the other and say, if they have a guard at the entrance to a parking lot and an arm that goes up and down, then all of a sudden they can restrict you from having your weapon in your car at work because they have a continuously posted guard and a barrier device. So what they've done is they've taken Section 6, which talks about prohibited places, and they've applied it to Section 4, which is talking about your right to keep your weapon in your car at work. I believe through the judicial process, those entities will probably lose that position, that Section 4 will stand over Section 6, but we'll have to let the courts kind of play it out. It was I tell you, we can write these laws and we can work on them for months and months, and there'll still be some attorneys that will figure out how to flip and flop them and turn them back on themselves. So that's kind of where we are on that. Gun shows was another piece of the bill. It's not really getting a lot of press, but there were federal guidelines for gun shows that have come down, and we've kind of mirrored those in the state. But one of the things that was in the bill as it left the Senate was it required a lot of bookkeeping on the individual sponsors of the gun shows about who buys guns, who sells guns, what guns are sold, and I pulled that out. I didn't really like the data keeping mechanism of what was in the Senate bill as it hit the House. I'm a fan of the government not knowing what I have. And even though I'm a part of the government right now, I don't plan to be for too awful long. I ran to minimize government, not to increase or maximize government. So I continually fight the desire in Montgomery and Washington to get into our lives and tell us, what we're going to do and what we're not going to do. That's pretty much the meat of the bill, and I'll be glad to answer questions as we go. One of the things, and I'll tell you, a lady actually approached me here in Cullman when I was speaking. I guess I was at the town hall event I did in Vineland. And I was actually speaking against the parking lot provision last year about this time. And a lady approached me. She was a nurse at, I guess not Children, Cooper Green Hospital. And she worked the evening shift. And she has a concealed weapon permit, which allows her to carry her pistol in her car or in her purse. To and from work, she said she drives through a war zone. And just stopping at a red light is dangerous in that area of Birmingham. And she likes to have her pistol with her. Once she gets in the parking lot, there's security guards and she feels safe. It's patrolled, cameras. However, it is against hospital policy for her to have that pistol in her car. And if she abides by hospital policy, then she would not be able to carry that pistol with her to work, and she would not be protected in those harsh areas in between the parking lot and her house. And so I kind of saw from a different perspective of how we were restricting an individual's right to protect themselves, and that was kind of where I started to turn a little bit. One of the things that I hit the BCA with that they might want to look at is if it's my policy as a business to restrict a firearm, completely on my property. And yet I do nothing to ensure that the individuals that come onto my property don't have a firearm. If I don't put up a device and I don't search every car and I don't guarantee, at least with some certainty, that there's no firearms in there, and an incident does occur, what's the likelihood that a trial lawyer could come after me for removing your right to protect yourself and not ensuring your state safety? And they all agreed that they were exposing themselves to some liability. And that by the way we've worded this law, the way it's been put into place, we've removed that liability on businesses. So while the BCA, their official position was, we don't particularly like it, on one side, they were comfortable with it. It actually gave them some liability protection that they had not previously had. And so a lot of the businesses are you know, there's a lot of back and forth, and every business is different, but their legal counsel is fairly pleased with the protection that this law gives for their liability. Yes, one other thing. Prior to this law, there was no mechanism for an individual in the state of Alabama to transport a pistol in your vehicle without a concealed carry permit. I don't have a concealed carry permit. My wife does. I took a load of kids to Birmingham several months ago. We had 2 church vans and our vehicle and another vehicle behind us, and went down to Birmingham at midnight, spent the whole evening jumping on trampolines. So about 3 a.m. I go out to get ibuprofen because I'm about to die trying to keep up with these kids. And I open the glove box, and there's my wife's .357. And I realize I am in Birmingham at 3 a.m. on a Saturday night with a weapon in this vehicle, and I have no mechanism of getting it home. I can't, it doesn't matter if I unload it, it doesn't matter what I do, where I put it in that vehicle, I am illegally transporting this firearm back home. One of the things we allowed for in this law, if you unload your pistol and you put it out of reach of the driver or any passengers in the vehicle, you can legally transport your pistol in the state of Alabama now. You never had that before. And a lot of people didn't realize it. I didn't know it until I started researching the gun laws in the state of Alabama. I had always thought when I was a kid going deer hunting that if I had a sidearm and I just unloaded it and kept it in the toolbox of the truck or in my hunting box, that was legal. But it wasn't. I was violating the law. And so we straighten that up, in my opinion, and try to give some allowance to be able to transport that way. Anyway, I'm going to shut up because I'll talk way too long. But that's it. I guess y'all want to do questions for me or let him speak and we'll vote? Okay.
Well, I just want to start out and say that I'm an NRA member and I'm a gun guy. I shoot, I carry guns, and I want to thank y'all for changing the original Senate bill that was introduced, because in 1978, as a young officer, I was standing between the Ku Klux Klan and the ACLU during the Congo Times Trial. 4 people were shot in Decatur when those 2 groups got to shoot out because they were armed. You know, somebody came by and shot our courthouse during that incident here in Cullman County. And as a result of that, the state legislature made a law that you could not carry a weapon to a demonstration, a rally, or a protest. And the original Senate bill, the original version of this bill, did away with that. People would have been able to carry guns. The Ku Klux Klan, the ACLU, or whoever could have been armed legally at one of these protest rallies. And we were really, really concerned about about that. That was probably my top priority, my top concern, and thankfully that was removed from the bill. Specifically for you as business owners, just like Representative Henry said, you can prohibit people, your employees, from bringing weapons inside your business. They can't bring it inside the shop, inside the warehouse. This provision is for parking lots. It's for parking lots. Now, on the parking lots, it says that they can have a weapon in the vehicle. If they have a pistol permit, it can be loaded and accessible to them as long as it's out of sight and locked up in the car when they're not in the car. And that can be the doors being locked. So it can be over the seat, or the console, or whatever. If they don't have a pistol permit, it has to be unloaded and it has to be secured out of reach of the passengers and the driver. So we interpret that to be in the trunk, and that's going to totally prohibit someone from carrying a weapon without a pistol permit on a motorcycle, because everything's going to be within reach of the driver. There's a lot of the details on this, just like Representative Henry said, that's going to have to be ironed out in court through case law as we interpret it versus the intent versus a defense attorney's arguments to the judge on what constitutes reach or what constitutes a guard. There's a lot of different things that we're going to have to actually probably work through as we go. Now, it also says that they can legally keep a rifle or shotgun in the vehicle if it's out of view, ordinary view, and it's unloaded. They have an Alabama hunting license. And it's in season. It's in hunting season. Well, the Alabama Game and Fish laws state that there is no closed season for coyotes, groundhogs, or feral pigs. So someone can carry a weapon 365 days a year as far as the open season goes. The limitations on what kind of weapon you can carry, it says any rifle, caliber, or shotgun. Any rifle caliber could be a 50 caliber barrel rifle. Okay. The only regulations on what you can't hunt with against coyotes, feral hogs, and groundhogs is you can't have a fully automatic weapon. You can't have a silencer on it. You can't have like a laser light or a flashlight attached to it. Anything else could be considered a hunting weapon. And it has to be unloaded. So out of ordinary view, ordinary sight, could be on the front seat with a towel over it. Unloaded means the loaded magazine is next to it. So it's unloaded, it's legal, it's out of view. Now it's loaded, and there you go, the 30-gun magazine. So it's unloaded.
There was nothing in that.
So you're going to have, you may come into a situation like that. If you look on page, I think it's page 24 in the handout, what would have been 24 before. You can take adverse employment action against somebody if they illegally have a weapon in their car. If they're not entitled to have a weapon, if they're a felon, if they've been convicted of trafficking in drugs, if they're not in compliance, if it's visible, just like the representative said, if they're showing it to their buddy, if they're taking down the vehicle. But you got to make sure that you're right, and if you do take adverse employment action, because they are entitled to recovery according to the Act. It's specified there under G. If you take adverse employment action against them, and they can show that it was, or reasonably believe that it was because they had a weapon in the car, and they're in compliance with the Act, and they're not prohibited from owning that weapon because of some other conditions. So that's something that you're going to have to really, you might want your attorneys to look at that. Make sure that you're going to be in compliance with that. of the things that I'd like to talk to Representative Henry and Buttram about are some things that we would like to see with the Police Chiefs Association, and I know what the sheriff, he wants to say about it too, the Sheriff's Association, but I gave you a copy of my pistol permits. I just got it renewed yesterday. It's the new one and the old one. The old one is on top and has a list of restrictions that the sheriff imposed for you to be able to have that permit. Okay, it includes not having your weapon in an establishment that serves alcohol or not while you're drinking alcohol. This bill supersedes any local ordinances or the authority of the sheriff to impose any restrictions on the pistol permit. The restrictions on the new pistol permit, you can see the back of the one below it. There's none. It also says that, under the old one, that if they were arrested for anything, that the sheriff had the right to pull that permit. If we got in a fight with somebody, they were resisting arrest, if we got in a high-speed chase, and they had a pistol permit, then we would pull that, send it back to the sheriff, and he could keep it. We believe that under the new law, that we can't do that unless it meets one of those criteria that prohibits them from owning a firearm. So that's something that may come out in case law. But the one that really concerns us is the no alcohol prohibition. And correct me if there's something, a law maybe that I'm missing, but right now somebody with open carry, if it wasn't prohibited on the door, it wasn't posted, if you go into Grumpy's or if you go into Moe's or if you go in someplace, you go to the bar and they could just knock them back. Yes, we could arrest them for DUI once they left. Yes, if there was a problem and they became argumentative or whatever, we possibly could arrest them for public intoxication inside. But the fact they have a weapon, there's no law or ordinance that would give us a right to do anything like that. Most of the states that have open carry either prohibits you from having a weapon in a place that serves alcohol, or if you go in, you can't prohibit you from drinking alcohol, or they actually, some states actually have a CUI, carrying under the influence, having a weapon and being intoxicated to a certain level. It's presumed that you're a danger to yourself or somebody else, just like driving. If you've got a weapon and you're intoxicated to a certain level. So that might be something that we could research for next year. That's maybe something that Alabama might be interested in to possibly keep from having incidents in the alcohol and firearms. I also passed out the section that refers to the open carry, or the fact that the law does not prohibit any other form of carry. This is just talking about the inside private property. Now, you own the property. You have a right, just like the representative said, to post a sign that says, we do not want firearms, no weapons, no firearms. The question is, and again, the representative mentioned it, implied consent versus express consent. There are some gun advocate websites that are saying that implied consent is someone actually physically has to come up to you and tell you, you've got to leave, we don't want you here, even if they've got to sign up. Again, that's probably something that the courts will have to go through. We'll have to see. If you have the right to ask somebody to leave your business or your property, unless it's a civil rights violation. You can't do it because of their race, their gender, or their ethnicity. But you have a right, as a business owner, to tell somebody, I don't want you here, I prefer that you leave.
But that is only for an unconcealed weapon, isn't it?
No.
It's
You
concealed.
can tell anybody to leave of course, if it's concealed, you're not even going to know it's there.
Right.
So it's not, shouldn't be an issue. Sheriff, did you want to say anything?
Well, you got an old permit in here. Since Cullman went wet, we took out provision 4 on the permit, or we changed it, where you can go into an establishment that serves alcohol. Of course, that's all mute now because we can't put any provisions on there. My biggest problem with the shell issue permits is I had always we got a question from 18 to 21-year-olds now. I'm being inundated with youngsters coming in and getting permits. Beforehand, I had and I guess I was violating their right, I don't know. But I had a separate supplement form for under 21 years of age to fill out. I asked for their parent or guardian's signature and their contact information, and I would always call the parent or guardian, whether it be a grandfather or father or whatever, and I would talk with them about the person that was applying for a permit. I always made sure that they were like a college kid going to school somewhere, needed protection. But just old Joe down the street that didn't have a job, 18 years old, I wouldn't issue anymore.
See, to me, you're doing exactly what should have been done, but without the state law in Alabama. Prior to this bill didn't set an age or anything.
Right.
It just said it has to be uniform throughout the state. If one, you can't, because there were some sheriffs that were given pistol permits at 18, am I correct?
I'm one of them,
Right.
but there wasn't many.
And so what was happening was you had this variation. So the law said we're going to keep it uniform. But what Sheriff Brady was doing is exactly what still should be done. There's nothing that prevents you from denying a permit to anyone if you feel they are going to be a danger to themselves or to the public.
Right, yeah.
I mean, that's the tagline at the end of the bill. He has sole discretion anytime he doesn't feel like an individual is capable of responsibly carrying that weapon concealed, they can be denied. And we gave them that power so that they could do that. So, and I.
Yeah, I'm not
No,
saying
I know,
that I'm
you and I
gonna issue
discussed it, right.
to a lot of these people that I have denied. I'm gonna stand my ground.
Exactly.
And they can get a judge to issue them a permit, I'm not.
He won't do it, because
Right.
the way the law is written, it gives you the ability to be the determining factor as to why you don't think.
But again, it's brought to light, the open carry issue. There's nothing we can do now, 18-year-old and above. They can come in your businesses and walk up and down your streets, open carry now also.
But they always had that right.
They always did.
They've
I said
always
it
had
was
that
brought
right.
to light by
Right,
this.
well, but the reason it was brought to light is because it was a growing test, if you will. Citizens around the state of Alabama were challenging law enforcement and local municipalities on their laws, and they were going in and they were challenging, and it was getting fairly heated. And every time it would go to the Court of Appeals or to the state Supreme Court, the charge would be overturned. Case law, time and time again, sided with the Constitution of Alabama that it's an individual's right to carry a firearm in protection of yourself, over and over again. It doesn't say 21, it doesn't say 25. It just states that an individual. And then we still have in the state of Alabama kind of over 18 as our kind of where your constitutional rights kick in.
But does it address if you had a 15-year-old carry, an open carry gun? Is that addressed in the law?
Not that I know of.
I think they were using previous law to come up with 18.
I agree with you, I just
Yeah.
specify in the law.
Yeah, well, it's federal law, anyone under 18 can't possess firearms, so I guess that's all.
And anyone under 21 can't purchase from a, what is it, FFA?
FFL.
So,
One of the things that concerns us as law enforcement is that when we get the call, if you saw somebody walking down 31 here on the sidewalk with this weapon, and they didn't have on a badge, what would you do? What? You call us? Okay. Well,
Yeah, me too.
it's my understanding under the law, we cannot stop that person and find out who they are or question them just because they're carrying a weapon. That is not a crime. That is not, we've got to have something else.
Presumption of guilt.
Well, or a reasonable suspicion that a crime has been committed or was about to be committed. Now, in the past, guys carrying a gun, we're gonna stop and check him out. Now, we can't unless we can develop some other reasonable suspicion besides the fact. So if you call, don't call dispatch and say, hey, there's a guy here with a gun down on the parking deck, because the dispatcher is gonna say, are they acting suspicious? Well, yeah, they got a gun. Well, besides that, are they acting, yeah, they're walking around.
Why not do, see, this is just I don't get the rationale of, okay, so guys walking down their street, you come up and approach him. If he's offended and evasive, to me, that's reasonable suspicion. Why do you have to verbalize, well, they've got a gun?
They're trying to provoke us.
They're acting erratic. That's reasonable suspicion. And so we've got to change.
Excuse me, Ed, all these case laws you're talking about with the open carry people that have challenged, that's what they do. That's what they're gonna do here also.
Right, but you're saying you want to check them out.
Right.
You're saying you just want to find out if
Because of
they're
public's
dangerous. Right.
Make sure they're not a felon in possession of a firearm.
Or psychotic
Stop
or
stolen weapons.
what have you, right.
something like that.
You can check them out. You can check, look, this was years ago, and before I got into any of this mess, I was, yeah. Yeah.
Yeah, you do.
I worked third shift, CT, Huntsville Hospital, in Decatur General Hospital, and so I kind of lived on that cycle anyway. Well, I was in Huntsville late one night, like 2 a.m., coming back from the store, and I missed a gas station, so I whipped around to turn back in, and a police officer pulled me over. All right, so it was a legal U-turn, but it was late at night, it was a little erratic.
Cause attention.
Right. So he pulls me over, and, he goes through everything, he says, sir, you got a tag light out. All right, appreciate that. And, he's got my license. He says, what are you doing in Huntsville at 2 a.m. in the morning? None of your business what I'm doing in Huntsville at 2 a.m. in the morning. And that's what I said. It probably didn't take 15 seconds, and I was outside being frisked, and within about a minute and a half, I was in the back seat explaining what I was doing in Huntsville. I didn't have a firearm. I didn't have anything. He had reasonable suspicion because of my actions and my attitude to check me out. We have not removed that.
Well, we appreciate your intent in writing it that way. But the sheriff and I just came from a training session with the District Attorneys Association, and their legal experts told us that we had to have a reasonable suspicion other than their Second Amendment right to have a weapon.
And I just gave you 2 or 3.
Well,
I mean, you just think outside the box, guys.
Well,
That's what I'm
that's-
saying. Just
that's-
use something other
exactly.
than the easiest.
well, and that's what we're
Attack.
telling, that's what we're telling our officers,
It's
that's what we're telling our dispatchers. But it's not that easy.
Oh,
Google open carry versus cops on YouTube and look at some of the confrontations between the open carry, the people who are videotaping it through the corner
And that's what they're
And
doing.
they
They've been doing that. How long have they been doing that?
for a long time.
Right. And it was growing.
Kenny, you not got somebody walking down the street with that weapon on it, you not got the right to check and see if that weapon is loaded or unloaded?
No,
So it can be loaded.
ready to go.
The only provision about loaded or unloaded is on private property or transporting the weapon without a pistol permit.
And that's always been. I mean, this is not, that part is actually not even addressed in this law.
Well,
Yeah, this has nothing to do with long gun. This was, what he's talking about really were things that were already in process, they were already in law, and they had already been one in case law on walking around with a long gun. That's not, that's not in here.
No.
Right. So, I've been to a couple of these kind of forums, and I love what you guys do.
No, actually, we're just
And
trying
his
to-
job, his job.
I don't think he does.
Look, no, I say this because I work